International Comity in Philippine Taxation. This refers to the mutual respect and recognition that sovereign states accord to each other's laws and institutions. In taxation, it means that the Philippines generally does not impose taxes on foreign governments, embassies and diplomatic missions, international organizations, officials and employees of these entities. This principle is rooted in customary international law and is reflected in various treaties and agreements to which the Philippines is a signatory. Application in Philippine taxation. Tax exemption for foreign governments and entities. The Philippines cannot tax foreign governments or their instrumentalities operating within our territory. This includes embassies, consulates, and international organizations like the Asian Development Bank, the United Nations agencies, and others. Exemption of foreign officials and employees. Foreign nationals working for these entities are generally exempt from income tax on their salaries if it is explicitly provided in the relevant international agreement. Filipino nationals working for these entities may not be exempt unless the agreement or law specifically includes them. Legal basis and jurisprudence. These include treaties and agreements. Examples include the Vienna Convention on Diplomatic Relations, the Convention on the Privileges and Immunities of the United Nations, and the Asian Development Bank Headquarters Agreement. These treaties often contain clauses granting immunity from taxation, which are respected under the principle of comity. Another basis is the Revenue Memorandum Circular number 31-2013. This BIR issuance clarified that exemption from withholding tax does not automatically mean exemption from income tax, and only those expressly covered by treaty provisions are exempt from both. We also have case laws. No? In the Commission of the Internal Revenue versus the Mitsubishi Metal Corporation, the Supreme Court upheld the principle of comity, ruling that the Philippines must respect tax exemptions granted under international agreements. In the CBK Power Company versus the Commissioner of Internal Revenue, the court reiterated that international comity limits the territorial reach of Philippine tax laws. Limitations and clarifications. Not all foreign entities or personnel are exempt, only those specifically covered by treaties or laws. Interpretative rules like the RMC number 31-2013 are used to clarify existing laws, not to create new tax burdens. And the retroactive application of such rules must be consistent with principles of fair play and justice as emphasized by the Court of Tax Appeals. Sovereign equality among states. Relevance to Philippine taxation and international comity. In the context of Philippine taxation, sovereign equality supports the principle of international comity, which means the Philippines does not tax foreign states or their instrumentalities operating within its territory. This respects the sovereignty and equality of other nations and avoids diplomatic frictions. It aligns with the territoriality limitation in taxation, ensuring that Philippine tax laws do not infringe on the sovereignty of other states. Constitutional limitation on taxation in the Philippines. These limitations are explicitly provided in the 1987 Philippine Constitution and interpreted through jurisprudence. They serve to balance the government's taxing power with the rights of the citizens. 1. Due process of law. Under Article 3, Section 1, no person shall be deprived of life, liberty, or property without due process. These laws must be reasonable and just, not arbitrary or oppressive, and is enacted through proper legislative process. Example, a tax that unfairly targets a specific group or lacks a legitimate public purpose may be struck down. Equal protection of the law. Also under Article 3, Section 1, taxpayers in similar circumstances must be treated equally. Clarifications must be based on substantial distinctions related to the purpose of the law and applied uniformly to all within its class. Uniformity and equity of taxation. Under Article 6, no, Section 28, taxation must be uniform and equitable. Uniformity should be same tax, no, rates for those in the same class, and equity, tax burden should be proportionate to the ability to pay, and supports progressive taxation where higher income earners pay more. Progressive system of taxation. Under Article 6, no, Section 28, Congress shall evolve a progressive tax system to ensure that taxation reflects social justice with wealthier individuals contributing more. Non-impairment of contracts. Under Article 3, Section 10, no law impairing the obligation of contract shall be enacted. Tax laws must respect existing contracts unless overridden by police power for public welfare. Free exercise of religion. Under Article 3, Section 5, protects religious freedoms. Properties and income used exclusively for religious, charitable, or educational purposes are exempt from taxation. However, commercial activities by these religious institutions are not exempt. Non-appropriation for religious purposes. Public funds cannot be used to support religious institutions. This ensures the separation of the church and the state in tax spending. Judicial, judicial review of tax laws. Under Article 8, courts have the power to review the constitutionality of tax laws. Taxpayers can challenge laws that violate constitutional rights. Exemption of certain entities. Under Article 6, Section 28, properties used exclusively for religious, charitable, or educational purposes are exempt from taxation. It also applies to non-profit institutions provided income is not used for private benefit. Delegation of taxing power. Only Congress has the power to impose taxes. Delegation to local government units or LGUs is allowed under Article 10, Sections 5 and 6, but must follow statutory limits. Territoriality and international comity. Taxation is generally limited to activities within Philippine territory. The Philippines does not tax foreign governments or their instrumentalities respecting international comity. The due process clause in the Philippine taxation. The due process clause in the Philippine taxation is a critical constitutional safeguard that ensures fairness and legality in the government's exercise of its taxing power. Constitutional basis. Under Article 3, Section 1 of the 1987 Constitution, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. In taxation, this clause protects taxpayers from arbitrary, oppressive, or confiscatory tax measures. There are two types of due process. The first one is the substantive due process, which ensures that tax laws themselves are fair, reasonable, and serve a legitimate public purpose. A tax law may be struck down if it is arbitrary or oppressive, or lacks a rational basis, or violates fundamental rights. The procedural due process ensures that the process of tax assessment and collection is fair. Taxpayers must be properly notified of any tax deficiency or assessment, given a chance to respond, protest, or appeal, and is assessed based on clear facts and legal basis. Procedural requirements in tax assessment. Under Section 228 of the National Internal Revenue Code and the related regulations, the Bureau of Internal Revenue must follow these steps. 1. Notice of discrepancy. The BIR should inform the taxpayer of the alleged discrepancies. The preliminary assessment notice. This is issued if discrepancies are not resolved. A formal letter of demand or final assessment notice. This formalizes the tax deficiency. And number four, and the last one, the final decision on disputed assessment. This is issued after protest or appeal. Failure to follow these steps can render the assessment invalid due to violation of due process. Jurisprudence supporting due process. In the Commissioner of Internal Revenue Fitness Racing, Inc., the Supreme Court emphasized that the taxpayer's right to due process outweighs the state's power to tax. Also, in the Commissioner of Internal Revenue versus the First Tumiden Circuits, Inc., no, the Court of Tax Appeals invalidated a new tax finding raised only in the FDDA ruling it violated the due process. Practical implication for taxpayers. Taxpayers must be vigilant in responding to BIR. They have the right to protest, submit supporting documents, and appeal to the Court of Tax Appeals if necessary. So any deficiency in notice or procedures can be grounds for cancellation of such assessment. Equal Protection Clause in the Philippine Taxation. The Equal Protection Clause in Philippine taxation ensures that all taxpayers in similar circumstances are treated equally under the law. This principle is enshrined in Article 3, Section 1 of the 1987 Constitution, which states that no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. Tax laws may classify taxpayers into different groups, income brackets, or business types, but such classification must meet four requisites to be valid. Number one is substantial distinction. This classification must be based on real and meaningful differences, germane to the purpose of the law. The classification must be relevant to the law's objective, should be not limited to existing conditions. So it must apply to both the present and future situation and applies equally to all in the same class. So everyone within the class must be treated the same. Uniformity and equity in Philippine taxation. This refers to the two key principles in tax policies. Uniformity means that tax law should be applied consistently across similar situations or individuals. For example, people or businesses in the same category should be taxed at the same rate, ensuring fairness and predictability. Equity, on the other hand, refers to the fairness in the distribution of the tax burden. This can be broken down into horizontal equity, wherein people with similar income or ability to pay should pay the same amount in taxes. Vertical equity, those with greater income or ability to pay should contribute more, often through progressive taxation. Non-imprisonment for non-payment of poll tax in the Philippine taxation. In the Philippines, no person can be imprisoned for non-payment of a poll tax or civil debt. as guaranteed by Article 3, Section 20 of the 1987 Constitution. This provision reflects a commitment to uphold human dignity and prevent undue hardship caused by economic circumstances. The prohibition against imprisonment for death was influenced by international human rights norms, including Article 11 of the International Covenant on Civil and Political Rights, which the Philippines has ratified. It also reflects a rejection of past practices where debtors were jailed, a system viewed as cruel and unjust. Non-impairment clause in the Philippine taxation. The non-impairment clause in the Philippine Constitution is a vital legal safeguard found in Section 10, Article 3 of the 1987 Constitution, which states, "No law impairing the obligation of contracts shall be passed." What does it mean? This clause protects the sanctity of contracts, ensuring that once a contract is validly executed, it cannot be altered or invalidated by subsequent laws. It applies to both private contracts and government contracts, including civil contracts like lease, sale, or loan, public utility contracts, and franchise agreements like Meralco and PLD. Implications for taxation. Separation of church and state. No? The clause reinforces the principle of church-state separation, ensuring that tax revenues are used for secular public purposes only. No government funding for religious activities. Government agencies cannot fund religious ceremonies, build churches, or subsidize religious organizations even if they serve charitable institutions or charitable functions. Protection of religious neutrality. The government must remain neutral in religious matters. Appropriating funds for religious use could be seen as endorsing or favoring a particular faith. Tax exemption versus appropriation. Tax exemptions for religious institutions, no, like churches and mosques, are allowed under Article 6, Section 28, provided their properties are exclusively used, no, for religious, charitable, or educational purposes. However, appropriating public funds to support this institution is strictly prohibited even if they are tax exempt. This is the summary, no? Non-appropriation clause. No public funds may be used for religious purposes. Taxation must serve secular public interest. Religious institutions may be tax exempt, no, but cannot receive government funding. Church-state separation reinforced through fiscal neutrality. Property tax exemptions, no? Religious, charitable, and educational institutions. They are exempt, no, if their property is actually directly and exclusively used for religious worship, charitable purposes, no, and educational purposes. Ownership alone is not enough. No? The use of the property is the determining factor. Key rule, actual, direct, and exclusive use. No? This rule is strictly applied even if a property is owned, no, by a religious or charitable institution. Any portion used for commercial purposes, no, is not exempt and will be taxed proportionally. Income tax exemptions. Institutional exemptions. Entities exempt under Section 30 of the National Internal Revenue Code includes non-stock, non-profit educational institutions, charitable organizations, religious institutions, and cooperatives registered with the CDA. They must secure a certificate of tax exemption from the Bureau of Internal Revenue. Principles governing tax exemptions. Strict interpretation against the taxpayers. Exemption must be clearly stated in the law. Liberal interpretation for public welfare. Exemptions for education, charity, and religion are interpreted favorably. Non-impairment. Once granted, exemptions cannot be arbitrarily revoked. And non-transferability. Exemptions apply only to the grantee unless otherwise stated. Veto of appropriations, revenue, or tariff bills. In the Philippines, the President has the constitutional power to veto appropriations, revenue, or tariff bills, as provided under Article 6, Section 27 of the 1987 Constitution. This is known as the line item veto. The line item veto allows the President to reject specific items in a bill, particularly in appropriation bills like the national budget, the revenue bills like the tax law, and tariff bills, no, like the import-export duties. This means that the President shall have the power to veto any particular item or items in an appropriation, revenue, or tariff bills, but the veto shall not affect the items or items to which he does not object. This means that the President can approve the rest of the bill while removing specific provisions deemed unnecessary, unconstitutional, or not in the public interest. Question is, can Congress override such veto? The answer is yes. If the president vetoes an item, the Congress or the House where the bill originated can reconsider the veto. What do they need? They need two-thirds, no, of all the members to vote, no, to override it, no. And if the bill goes to the next house or the House of Senate, no, two-thirds of the House, that House, no, or the Senate, shall also approve. Once two-thirds of them approves the vetoed items, it becomes law. Okay? This process ensures a check and balance between the executive and the legislative branches. Why is this important in taxation? This prevents unjustified spending or tax provisions from becoming law. It allows the president, no, to fine-tune fiscal policy without rejecting the entire bill, no, and ensures executive oversight over national revenue and expenditures. Of press freedom. In the Philippines, taxation can infringe, no, on press freedom when it is used not as a neutral fiscal tool but as a weapon to suppress dissent or control media operations. Here is a breakdown of how this issue is viewed legally and politically. Legal principle: taxation versus press freedom. Freedom of the press is protected under Article 3, Section 4 of the 1987 Constitution. Taxation is constitutional as long as it is a general and fair exercise of the government's power. However, taxation becomes unconstitutional when it acts as a prior restraint, no? A measure that directly or indirectly prevents the press from freely disseminating information. Taxation infringes on press freedom if it is excessively high and targets media entities disproportionately; it is used to financially cripple or harass specific media outlets; and it is applied in a discriminatory manner, unlike how other industries are taxed. Grant of franchise. Tax exemptions in franchise grants. Franchise holders may be granted tax exemption through a clause typically worded as "in lieu of all taxes", meaning the franchisee pays a fixed franchise tax instead of being subjected to other national or local taxes. This clause has been used in franchises granted to telecoms, utilities, and media companies. However, its application has evolved due to changes in law and jurisprudence. Here is a summary of tax implication. Legislative franchise? Well, yes, no, if in lieu of all taxes clause is included. However, they are still subject to local taxes unless exemption is explicit. Administrative franchise. Generally, they are not exempted. But of course, they are subject to national and local taxes as well. Franchise with equality law clause. No automatic exemption and must be clearly stated in law.